Good morning, everyone. Excuse me, and welcome to this morning's business meeting. I want to ask first for everybody to please bow your head for a moment of silent reflection, please. Amen. Thank you. Mr. Minges.
Good afternoon, Mr. Chairman, Commissioners. Our first item of business is to set the next commission meeting, which, due to the Martin Luther King holiday, is scheduled for Wednesday, January 30th at 2 p.m.
Okay. Wednesday, January 30th at 2 p.m. will be the next meeting. Thank you.
Our only matter for consideration today are petitions for rehearing or reconsideration of order number 2018-804 and docket numbers 2017-207E, 2017-305E, and 2017-370E.
Mr. Chairman.
Commissioner Elam.
Mr. Chairman, when this commission reached its decision in this case back in December, we set permanent rates that are comparable to and slightly lower than the significant rate reductions for SE&G customers as called for by the General Assembly in its Act 258. Those rates are more than 15% below the established rates in place prior to abandonment. In doing so, the issue of SE&G's prudence in this project after March 12, 2015 became no longer legally relevant to our analysis, given that the company's agreement not to seek recovery of capital costs after that date. However, our ruling should not have been perceived as even an implicit finding of prudence on our part for capital costs incurred after March 12, 2015. Nothing could be further from the truth. Several parties have petitioned this commission to make a specific finding of imprudence as to the cost incurred by SE&G during the construction of the project. In order to address these concerns and to emphasize the need for all regulated utilities to be transparent in their dealings with OR in this commission, I move we make a clear and unequivocal finding. The company acted imprudently by not disclosing material and even potentially decisive information to ORS and the Commission. Due to the lack of transparency, the lack of forthrightness with regard to reports and studies available to the company, this Commission was effectively denied the opportunity to fully consider the prudency of continuing to expend resources on the project with all information available at the time. Under any definition of the term prudence, the company was imprudent in its actions, in this case, with regard to costs incurred after March 12, 2015. We agree with ORS that it is essential to restore public trust for this commission to acknowledge that the regulatory compact between the utility and the regulators was broken by SE&G. However, these actions were addressed by this commission in our Order 2018-804. The company agreed to significant concessions in response to its actions and offered Plan B levelized to accomplish this. The responsibility of the company, created by non-disclosure, lack of transparency, and forthrightness, has a price. That price is roughly $3 billion to be returned to the ratepayers through mechanisms in Plan B levelized as approved in our order. We have ordered the company to refund over $1 billion to ratepayers through lower rates going forward and ordered the company to provide approximately $3 billion in benefits to ratepayers over time. The costs for SE&G's action are significant and have been accounted for by this commission in our order. We believe this result in finding emphasizes the need for all regulated utilities to be transparent in their dealings with ORS and this commission. This commission has been charged with protecting customers of investor-owned electrical utilities from responsibility for imprudent financial obligations or cost. We have ordered the payment of resources from the company for the benefit of ratepayers that maximizes relief within the limits of the authority of the Commission. Maximizing customer benefits, Plan B levelized offered by Dominion reflects a careful balancing of accounting, tax, and credit considerations, among others. Under Plan B levelized, the proposed recovery of $2.768 billion limits costs and the associated prudence determination to investments made by SE&G on or before March 12, 2015. Importantly, though, the ORS does not contest the prudence of investments made before March 12, 2015, and our order appropriately rejected arguments by other parties seeking an earlier date for cessation of recovery. By voluntarily limiting the NND rate-based recovery to that date, the conduct of the company discussed above is made no longer legally relevant to the analysis, since the company has voluntarily removed its request for capital costs beyond that date. I find the 2006 South Carolina Supreme Court case, Sloan versus Friends of the Hunley, instructive in this regard. While several petitioners have raised the specter of the utility somehow later pursuing recovery for capital costs incurred after March 12, 2015, this would not be possible under the law on abandonment. The current proceeding is the only proceeding in which recovery of costs in abandonment may be pursued. Joint applicants are not seeking recovery of capital costs incurred after March 12, 2015, and are hereby expressly foreclosed from pursuing recovery of such costs in any future proceedings. No capital costs incurred after March 12, 2015 may be recovered as prudent. Indeed, at the conclusion of this case, the legislature's Act 258 will abolish the BLRA, including the provision that allows any recovery in abandonment. ORS, AARP, Friends of the Earth, Sierra, and Mr. Knapp assert that it was error for the Commission not to require SC&G to refund past revised rates collections. ORS seeks a return of revised rates collected after March 12, 2015, or associated with amounts of project investment in excess of $2.772 billion. Other petitioners seek refunds going back further, in some cases back to the beginning of the project. As to the other petitioners, I move that we find their claims for an earlier date are not supported by substantial evidence in the hearing record. These parties never specified the amounts of such claimed refunds. They have also failed to make an adequate evidentiary showing or a legal justification to set aside legal precedent regarding the filed rate doctrine and retroactive rate making for capital costs prior to March 12, 2015. Regarding ORS's arguments, Order number 2018-804 states that Plan B levelized provides for write-offs, ratepayer refunds, and ratepayer restitution totaling approximately $3 billion. Refunds are further addressed and included in the Commission's order and the tariffs subsequently filed by SC&G relating to the capital cost rider. Under the capital cost rider, regulatory liabilities will be established for refunds of the Toshiba settlement as well as amounts previously collected under the BLRA in the amounts of $1.032 billion and $1.007 billion, respectively. The total amount of $2.039 billion in refunds and restitution under the Plan B levelized is designed to compensate ratepayers for the time value of the delayed refund of the Toshiba proceeds, as well as provide refunds and restitution for any rate overpayments previously collected under the BLRA. By requesting refunds of revised rates collections, the petitioners are asking, in effect, for SC&G and Dominion Energy to add additional bill mitigation funds beyond what has already been approved in our order. The combination of immediate write-offs and long-term funding from Dominion Energy was sufficient to achieve bill levels comparable to those temporarily imposed by the General Assembly through Act 258, which has passed constitutional muster. The United States District Court held in South Carolina Electric and Gas versus Randall that the rates imposed in Act 258 and Resolution 285 had not shown to be confiscatory. As an intervener in this case, Speaker of the House Jay Lucas has argued that setting rates significantly lower than previously imposed temporary rates could create uncertainty for ratepayers due to constitutional challenges or bankruptcy concerns. Such uncertainty would be to the detriment of the rate-paying public. Further, the Commission was urged to adopt a rate within the constitutionally allowed zone of reasonableness established by the experimental rate adopted in Act 258. We agree and find that deviating from those rates, as advocated by the petitioner seeking reconsideration, could raise constitutional difficulties which could delay the implementation of rate decreases approved in this case. As such, the rates approved by the Commission in Order number 2018-804 represent a balancing of all interest in this case, recognizing the arguments on specific monetary issues and the potential legal issues attached to those arguments. It further represents this Commission's effort to bring finality and stability for SC&G's customers in this matter. Therefore, I move that we find this issue was appropriately addressed in our order. Next, several parties seek reconsideration regarding merger conditions to govern potential affiliate transactions that could occur between SC&G and Dominion at some point in the future, should the Atlantic Coast Pipeline extend into South Carolina. While I understand this concern, I believe this issue was appropriately addressed in our order. First, under Code Section 5827-2090, this Commission already has broad oversight authority over all persons or corporations affiliated with a jurisdictional electric utility. The burden of proof is on the utility to establish the reasonableness, fairness, and absence of injurious effect upon the public interest regarding fees or charges growing out of any transactions. Unless those standards are met, as determined by the Commission, the fees and charges shall not be allowed by the Commission for rate-making purposes. Moreover, Order Number 92-931 places additional reporting requirements on SC&G and SCANA's regulated affiliated companies regarding affiliate transactions, including the transfer of real property. And post-merger, they would apply to Dominion as well. The requirements in Order Number 2018-804 go even further. Some of those requirements memorialize a settlement agreement between Transcontinental Gas Pipeline Company, SC&G, and Dominion Energy, where those parties have voluntarily agreed to certain protections that will apply if SC&G seeks to secure more than 100,000 decatherms per day of additional natural gas transmission capacity from an interstate pipeline. In such cases, SC&G will be required to issue a request for proposal. If SC&G chooses to purchase capacity that is not least cost capacity offered, then SC&G must request a public proceeding before the Commission to justify the purchase. Also, pages 100 through 101 of our order set out significant and far-reaching merger conditions regarding affiliate transactions between Dominion and SC&G. Therefore, I move that we find this issue was appropriately addressed in our order. I would ask, however, that if Dominion chooses to file an application with FERC regarding the extension of the Atlantic Coast Pipeline into South Carolina, that it copy the ORS and the Commission with its federal filing. Mr. Chairman, other than as I have set forth in this motion, I move that the petitions for rehearing and reconsideration be denied. A full written order containing the Commission's findings will follow. So moved.
Thank you. You've heard Commissioner Elam's motion. Are there questions or comments from commissioners?
Mr. Chairman,
Commissioner Urban.
I commend Commissioner Elam's motion that we include the specific finding that SC&G acted imprudently in any costs incurred, capital costs incurred after March 12, 2015. It is essential to restore public trust, and this finding will go a long way in acknowledging that the regulatory compact between SC&G and ORS and the Commission was broken by SC&G, and it also puts all other regulated utilities on notice that we take this matter very seriously. In any future proceedings, we're going to hold them accountable, and we're going to expect transparency from any filings and representations made to ORS and the Commission going forward. I also agree with Commissioner Elam that to try and go back and change rates going backwards, as advocated by some petitioners seeking reconsideration, runs the risk of creating constitutional and legal issues which could delay the implementation of the rate increases that the Commission has approved in this case, which would be a terrible result. The ratepayers need immediate relief. It could take years to resolve potential appeals, and that does not serve the ratepayers. It does not serve the state well, and it would not be in the best interest of the ratepayers or the state. And for those reasons, I fully agree that we should stay with the rates that have been reviewed by the United States District Court and found to be appropriate, as the court found they passed constitutional muster. And finally, I agree that before the Federal Energy Regulatory Commission is faced with a request to permit the Atlantic Coast Pipeline extension into South Carolina, that the Office of Regulatory Staff and the Commission should have written notice so that Office of Regulatory Staff can make a determination as to whether they wish to intervene in that proceeding. There may be issues that are unique to our state of South Carolina, which would need to be raised in that proceeding. And therefore, I think that's an appropriate finding as well that should be included in the order. For those reasons, I support the motion.
Thank you, Commissioner Urban. Other commissioners, questions or comments?
Mr. Chairman.
Yes, sir. Commissioner Williams.
Thank you, Mr. Chairman. Commissioner Elam, I appreciate your motion. What I would like to comment on specifically is the finding of imprudence. There's power in the name, and the record is clear that there was a lot of information that was not given to this commission, and it may be defined different ways. Maybe more transparency was necessary. Maybe it was a business decision. But at the end of the day, it was imprudent. And I think it's important that we say that, and I appreciate your motion making it clear that it was wrong for this commission not to be given information necessary to make a full decision on that new nuclear development. And so regardless of what the explanations we received, it's important for us to put a name on the actions by the company, and those actions were imprudent. So for that, I support your motion, and I appreciate you making it.
Thank you, Commissioner Williams. Any other comments? Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Chairman, I too would, during this discussion phase, would like to acknowledge some of the comments of my colleagues to my right. There's been a lot of discussion about the Atlantic Coast Pipeline. It's very clear that no state in America has interstate jurisdiction for natural gas pipelines. They do have, some states do have for crude oil and petroleum product pipelines. I think along with this language, with us requesting that Dominion copy the Commission and the Office of Regulatory Staff in any would-be filing before FERC appropriately addresses that. Some state commissions have the right to intervene in a federal case before FERC. However, in South Carolina, it would be the Office of Regulatory Staff. So we've requested that they, in this motion, that they be copied on any federal filing. Also, as a result of our hearing, this commission has gained a lot of say-so, if you will, or authority that we might not have had as a result of the settlement with Transco. Some of you may remember Transco intervened. Initially, we weren't allowed, and through oral arguments hearing, we reconsidered, allowed Transco to intervene, and as a result of that settlement, this commission now has the authority to either have commission approval or the least cost option. And regardless of what the motive might be for a filing, if this state is able to represent itself before FERC, I
I certainly think that we've done all we can do. And the statute that Commissioner Elam cited in his motion and the order going way back to 1992 that Commissioner Elam cited also deals with affiliate transactions. So this commission has used every tool at its disposal in this matter. And I commend Commissioner Elam and Commissioner Irvin for your comments regarding that. And lastly, I'd like to reiterate what Commissioner Williams said. I, too, applaud Commissioner Elam for utilizing the word imprudence in his motion. It was important that that be in the motion for me. And with that, Mr. Chairman, I'm going to support his motion.
Thank you, Commissioner Whitfield. Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Chairman, I just have one point I'd like to make concerning the Atlantic Coast Pipeline, and I appreciate the information that Commissioner Whitfield has provided us, but I think a fear that many people had before was the fact that the cost of the pipeline, if it came into South Carolina, especially in the PD for economic development and agricultural needs, it would bring competition that it's apparently is needed, because we have many industrial parks that have no availability of natural gas. We have swine producers, turkey producers, chicken producers that have no ability to receive natural gas. That would be a tremendous asset to them. But the fact is that nobody pays for it except the users. The end users are the ones that would pay for it. Other ratepayers would have no responsibility or no obligation to pay any of the cost. And with that, Mr. Chairman, I do appreciate Mr. Elam's motion and support it fully. Thank you, Mr. Chairman.
Thank you, Commissioner Hamilton. Commissioner Howard.
I, too, want to support Commissioner Elam's motion. It's absolutely imperative that we do determine that imprudency was the product of this case, and that imprudency did keep information from us that we would need to make a final decision. And I, too, agree with the motion on the pipeline. I think we've got it covered. Thank you, Mr. Chairman.
Thank you. Thank you, Commissioner Howard. Anything else from commissioners? All right. You've heard the motion. All in favor, please say aye. Aye. All opposed, no. The motion carries. Thank you. With that, this hearing is adjourned.